Hello, we'll give it just a minute to let folks get into the room and then we'll get started. So thank you all for joining us today. I'm going to give it about 30 seconds and then go ahead and jump on into the conversation. I think it looks like folks are coming into the room so far. All right. Well, my name is Jenny Mattingly, and I'm the Vice President of Government Affairs for the Partnership for Public Service. For those of you who are unfamiliar with the partnership, we're a nonpartisan nonprofit working to build a better government and a stronger democracy. And we do that through policy ideas on how to make government work better. We have leadership development and workforce programming, and then we convene conversations like this one to help support the federal workforce. And we are here to support you as best we can through sharing resources, plain language explainers, and continuing to do what's the hallmark of the partnership, which is sharing the stories of the incredible work that federal employees do for the country. So starting off, want to thank you for your service and thank you for what you do for your agencies and for your community. And with that, I am going to do a few quick housekeeping notes, and then we'll dig into today's content on Merit Systems Protection Board, and I'll introduce our guest in a moment here. Quick disclaimer before we kick things off. Content provided during this session is for informational purposes only, and it's not intended to provide legal guidance. If you require legal advice, we recommend consulting with a qualified attorney who can assess your unique circumstances. Everything today is sort of broad, general information to help you make sense of how the processes work. Throughout the webinar, we will answer questions that you've submitted while registering. Thank you for doing that. But you can also submit a question through the Q&A function, and we will work to get through some of those as well. We're not going to be able to answer every question, but we do have FAQs on our website, and we'll have other explainer series that will dig into topics in the future. So definitely be on the lookout for more webinars in the coming week. And this webinar is being recorded, so it'll be posted on our website in about a day or so after this takes place. So you can certainly share it with friends, check it out again if you need anything. And finally, while this discussion is geared for federal employees, it is an open forum and we may have folks joining us from other communities, including industry, media. But the questions we're going to be focused on and the information is really for federal employees and those who are recently feds. So first off, I'd like to introduce our esteemed guest today, Limon. Can you please introduce yourself for everybody?
Thank you, Jenny, for this invitation, and thank you for the partnership for making this platform available. This is certainly a critical time in the public workforce right now, and it's an honor to be here. So as Jenny said, my name is Limon, and more recently, I had served as the acting chair, the vice chair, and a member of the Merit Systems Protection Board, which is a wonderful agency we'll be talking about a little bit more. But I just want to also let you know, prior to that, over my 30 years of federal service, the vast majority, or 27 years, has been in a career position. You know, it started when I served at the Peace Corps in Honduras in the 1980s. And then later on, I joined the Office of Personnel Management, much in the news today. I worked in their general counsel's office. Later within OPM, I managed their Office of Administrative Law Judges, and even worked on the Office of Compliance, making sure that agencies are following the merit system principles. From there, I had an opportunity to move into more of an HR traditional role, where I became the first ever Chief Human Capital Officer, or CHICO, at the Corporation for National Community Service, a wonderful agency doing volunteer programs within this nation, AmeriCorps, Senior Corps, for example. Loved that opportunity. Later on, I had an opportunity to move over to being the Deputy Chico at the State Department, which kind of matched a little bit of my interest on international issues and working on that mission. And eventually, I found myself becoming the Chief Human Capital Officer at the Department of the Interior. I'm originally from the West Coast. It was great to be with such a large department that spanned all the work that primarily also worked out west, you know, National Park Service, Bureau of Land Management, Bureau of Indian Affairs, U.S. Geological Survey, Bureau of Reclamation, many, many more. So I thought I was going to remain as a career employee and then retire as a career employee. And then early in the Biden administration in 2021, I received a phone call, unsolicited, from the White House saying that they were looking to interview people to join the Merit Systems Protection Board and to be part of that 3-member board to eliminate the backlog of cases that were piling up in the 2017 to 2021 era, in which there was not a quorum. And so it was an honor to receive that phone call and to go through the Senate confirmation process on unanimous consent. It truly was an honor to be selected to join, get to know the employees and the judges who work there. And I also have to couple that experience with having served 16 years on the OPM Chico Council, in which I worked with many department Chicos over that time period, and of course, all the small agencies as well. So that kind of encapsulates a little bit of my background on how I ended up in that position. And I'm really looking forward to this discussion on what resources are available to public employees, and what's a little bit more what to expect if you go before the Merit Systems Protection Board.
Thank you, Ray. There's so many things we could dig into with that career. So many questions, but we'll limit it for today to MSPB, although you're not off the hook for later things. But I think for a lot of folks, these are some of the most amount of questions we have is, how does the MSPB work? What does it do? What happens through the process? What can people expect? So that's what we're going to dig into today, is really taking it from the perspective of Fed. What happens?
Right.
If I'm thinking about the MSPB, but I thought maybe we should start a little bit with, I always assume people know what the MSPB is, but they don't necessarily, or they don't know kind of the breadth of what it does.
Right.
So could you give us a little background first on MSPB, kind of a 101 on what it is?
Let's do that. And by my disclaimer, 3 weeks ago, my political term ended. So I'm no longer with the board, and recently entered into federal retirement. So I'm excited about my next chapter. But what really is interesting about the board, and you may have heard about this historically, you've heard about how this country was created, the different presidents selecting people for their administrations, and it was in the mid-1800s we knew about the spoil system, meaning that people were put into federal jobs with little to no effect related to qualifications. It was primarily a loyalty test to the president and the political party in which they came from. That all changed in the 1880s with the passage of something called the Pendleton Act, in which for the first time, Congress put together opportunities for employees to be examined and to introduce the concept of merit into the hiring and into management of the federal workforce. Interesting enough, fun fact, one of the commissioners of that Civil Service Commission that was created by the Pendleton Act was Teddy Roosevelt. And I had that opportunity to sit in the same seat that Teddy did, some decades later. So getting to that, in 1978, at the end of the Watergate period, in which there was an acknowledgement that the executive branch overstepped its constitutional duties and responsibilities, Jimmy Carter, the reformer, came in and said, I've been hearing a lot of things about accountability. What can we do to ensure that poor performers are dealt with, and what agencies can do to remove poor performers? So that was a really big part of the Civil Service Reform Act. But the other half of that was also ensuring agency accountability, that they follow the rules, that they provide due process. And coming out of that Civil Service Reform Act was to eliminate that agency that was doing some of that, the Civil Service Commission, into 3 different agencies. One, the Merit Systems Protection Board, to focus just on that, supporting merit, making sure that agencies do not violate prohibited personnel practices, and provide that due process, if you will, kind of adjudicating that tension between employee accountability and agency accountability. 2 other agencies was the Office of Personnel Management. Again, an agency that I worked on that was supposed to be handling or charged with handling policy matters to make sure that agencies are taking all the advantages of civil service rules and procedures. And then the Federal Labor Relations Authority, another quasi-independent agency to deal with union grievances and issues that would come up from a collective bargaining agreement. Within the board, we did also have an Office of Special Counsel, and they were to hear whistle complaints and, if you will, prosecute cases that involve whistleblowing actions. Some years later, about 10 years later, after the passage of the Civil Service Reform Act, Congress decided, you know what, let's peel the OSC out of the MSPB so they could be treated separately, also be an independent agency to prosecute cases, and the board would remain as a quasi-judicial independent agency to adjudicate those claims.
Thank you for that, because I think that's the piece where, I also want to throw out that MSPB, just for folks on the phone, also has a whole research arm. They have a lot of great reports, data, other things. As you're thinking about, if you're like me and like to dig into the weeds sometimes about what, employee accountability, probationary periods, there's some great reports on those from several years, many years ago for those of us that have been around for a while, but there's a lot of information to explain some of these issues of merit and other things to employees as well.
It's a critically important function that the MSPB also does, as you said, on the studies and evaluations. When I was both as an attorney for OPM years ago, as an HR practitioner, I would rely a lot on the MSPB publications because they would look at what's working and what's not. What are the best practices that agencies are doing? And so that function, that policy and evaluation function is very, very important that the board continues to do.
And so for folks who are looking for more resources, that's certainly one place to go is to MSPB's site and look at some of those background.
Right.
But for those folks who are really thinking more tactically, one of the questions we're hearing a lot, I know you are too, we've got probationers who have been let go from agencies, there's talks of rifts, people are wondering, can you appeal? What does the appeal process look like? Because that's certainly a large piece of the Merit Systems Protection Board. I'm wondering if you can sort of walk through what, if I'm, a federal employee and I decide I want to appeal a case, sort of what do I need to think about and what are the options to appeal?
Right, that's a great question. And sometimes as a government, we do not do a very good job in explaining all the different routes that employees can go to. Some of this information may have been provided to you during your onboarding process and where you're giving hundreds of forms to look at and review. So some of that information may be in there, but it just didn't become kind of relevant until in some ways today. So here we are, and if you're an employee, there are different venues or forums that you can go to, and each forum has its own separate levels of jurisdiction, meaning what types of cases can it hear. So you are familiar, would imagine, with the Equal Employment Opportunity Commission. If there's something that happens to you at the workplace that infringes upon your employment and it involves a Title VII civil rights claim, you can go to the EEOC and file a complaint, through an informal process, and then later on it could become formal. You may have also heard, I referred to it just earlier, the Office of Special Counsel that's charged with whistleblowing complaints, in which if you receive some level of retaliation in the workplace based on identifying some type of fraud, waste, or abuse, or some violation of law or procedures within your agency, you could go to the Office of Special Counsel and file a complaint. And they will look at that. And if there's merit to it, or they believe that they can represent you, then in fact, they would take your case and go to the Merit Systems Protection Board. And that did happen to me recently.
That's right.
When the last week before I moved out of the board, I did receive a stay request in which the OSC was looking at complaints related to probationary employees that they were not being treated fairly. In fact, there were evidence of prohibited personnel practices taking on. So that decision or that opportunity did come to me. I looked at the facts of the case, the law behind it, and I did grant that stay to allow those employees to go back to the positions while OSC continues its investigation. And then the other agency that I kind of referred to earlier, the Federal Labor Relations Authority, if you are a member of a bargaining unit and you believe that the agency violated part of the collective bargaining agreement, you could work with your union representative and file a grievance in which a case could go before the FLRA as well. And I would be remiss if I didn't mention the Office of Inspector Generals, in which you could also go to alert them to any fraud, waste, and abuse that you may see happening within your agency. So there are multiple forums for you to raise your hand and say, hey, something's not right. I'd like for you to look into it. And there are avenues to do that.
And I think that's a place to stop and just make sure people understand, because I get this when I'm out talking, is if you're in a bargaining unit, so whether you pay dues to a union or not, and you can look on your SF-50, it'll tell you whether you're in a bargaining unit. Some of what we're talking about with appeals may be different, because if you have a collective bargaining agreement or something at your agency, there may be a different route to avenue for things.
Right, that's a really good point. And just to get a little wonky on you, the SF-50 is part of the official personnel file, your OPF, that kind of chronicles your tenure through the government. And first of all, it's a very important file. And I would recommend to everybody, if you do, you should have your access to your eOPF. Don't wait until something tragic happens. You should make a copy of all your SF-50s and keep them with you. So I kind of highlight that. But if you're kind of wondering, am I in fact covered under a collective bargaining agreement, you could look actually at box 37 in your SF-50, and it'll have a number designation code. If it's like 48888, you're likely ineligible, meaning that you're probably an HR employee or maybe doing legal work, doing EEO matters, which makes you ineligible to be part of a collective bargaining agreement. 7777 will say that you're covered under a CBA, but you may not be associated to a particular union bargaining unit or a BU. Other than, you could have other numbers in there which would tell you, yep, you are assigned to a particular bargaining unit, and that's why those codes are very, very important. And you need to be aware if you're covered, because if you do receive an action, let's say it's some kind of adverse action, we'll talk a little bit more about that, your agency is required to give you a notice of that, and embedded in that information is a notice of elections, meaning highlights which forums you're allowed to go to. So that's, again, a really important reason to know whether or not you're covered under a bargaining unit.
That's a good segue into one of the questions we've gotten from folks online is, can you talk a little more about the difference between how you elect OSC versus MSPB? And I know, again, some OSC cases end up at MSPB, but just for folks online, if I was, you mentioned a little bit about waste, fraud, and abuse, but there's, the prohibited personnel practices and other things that may come into play.
Right. Well, first of all, it is not easy, and there are resources out there, going to these individual agencies and explaining how to file a complaint, very, very useful. And so even, of course, at the Merit Systems Protection Board, its webpage will explain who can file, and then more importantly, how to file. So in these different forums, they do have limited jurisdiction. So for instance, at the Merit Systems Protection Board, they're going to primarily be hearing cases in which there's been an adverse action that looks like a removal based on an adverse action, some conduct related activity, or based on performance. It could be related to a demotion in which one of these things occurred to you and now you're being demoted, or if it's, say, a long-term, more than 14-day suspension. These are activities that you absolutely have a right to appeal to the Merit Systems Protection Board. They also hear cases from veterans who may not have received their proper preference, or there's been a hostile work environment based on a veteran status. These statutes are either called the Veteran Employment Opportunity Act or USERRA. And so there are ways for veterans to bring cases before the board, and then also believe it or not, we also hear some retirement cases, meaning that if you file your retirement paperwork at OPM and OPM comes back and says you're either not eligible or you have an issue with the dollar amount, after working your administrative remedies through OPM, if OPM still says something you're not happy with, you could file a claim to the board. So What's important to remember though, as an employee, you bear the burden of proof, if you will, to show that the board has jurisdiction over your claim. And if it does, then that burden of proof then switches to the agency to prove that the removal was appropriate, the motion was appropriate, et cetera. So that's very important for the employee to know that you do carry the burden of proof when it relates to jurisdiction at the front end. And so that's how you bring your cases before the board. Similarly, between the EEOC, you should also be given guidance from your agency that you could also bring claims before the EEOC. And that they should also explain that process to you. So that notice, which is part of due process, is terribly important for the agencies to do it and to do it correctly. And if they fail to meet that notice requirement, we've seen cases in which the board has reversed those actions because the agency failed to properly notify the employee of their appeals process.
And those notice periods are typically in statute or regulation or other places. So if you have questions out there, it's certainly public on what those notice periods are. But that brings me to actually a separate sort of time frame, which people are asking about as well, is for all these folks who are thinking about filing, there are typical timeframes as well that they have to file in. I think for probationary period, is it 30 days from notice?
Most times when an agency is taking an action against you, you will have 30 days to bring your appeal before the board because there are time constraints, Shinny said, related to these appeals.
And if somebody's going to appeal, and this is something, we were just talking about, knowing what's your burden of proof, what's the agency, can people appeal by themselves? Do they need a lawyer? How does, what have you seen in terms of cases?
So many of the cases that become before the board are what is known as pro se, meaning that you don't need necessarily legal representation to bring your case. You can bring it on your own. There are ways to complete the filings that you would need to do on the board's webpage. But many employees can in fact be represented by legal counsel as well. And I think what's a little bit unique to the situation that we're seeing right now with these mass firings, that these cases are likely, there's a lot of interest within the legal community to help represent you or to learn more about how to be part of a class action lawsuit. So I think in these situations in which we're seeing unprecedented types of actions being taken against employees, it may behoove you to seek legal representation in these cases.
And that'll help you figure out, EEOC, OSC, it helps you kind of navigate, and it helps you navigate what info do you need as well, because that's another question we hear a lot. And we will put a link in the chat, and it's on our website too, that comes from Civil Service Strong. That's a great, how do you walk through, how do you file at the MSPB if you're gonna self-file? So that's a good one, but we'll talk about that a little bit is, if somebody's going to do a pro se filing, they're gonna file themselves, sort of what do they need? What do they do? They can just go to the website.
Right. So these, just a little bit more background about the MSPB, MSPB has about 190 employees, so it's not a very large agency. And I think about 60 or so are what are known as administrative judges. These are the individuals who will be receiving your initial appeal. And embedded within those instructions, it's going to ask you, be sure to provide a copy of the notice that the agency gave you related to your firing or discipline. And it'll also ask you to provide additional information that you think is relevant for the administrative judge to review your case. Now, what's going to happen next is you'll get an acknowledgement order from the judge. And you'll want to read that very, very carefully because he or she will then state, well, here's what I'm hearing as far as what you're bringing the issues. I may need some additional information. Are there additional claims that you want to make? And so you are going to be going through an adversarial process in which you will be provided to, identify witnesses and information. Similarly, as the agency will also be given that opportunity to provide evidence and information. And going through that entire process, then a judge will order a scheduling order. He'll talk about going through discovery, where you have an opportunity to ask for additional information of the agency, and then similarly, the agency could ask additional information from you. Eventually, that will all gear up towards having a hearing. And that hearing can either be in person or over video, depending on what the parties agree to. And within all of that, one thing that I do think that these amazing judges have a lot of experience in, they're dealing with pro se appellants. They will want to make sure that they have an opportunity to fully present information to best, bring their case forward. And they will work within a time frame of about 120 days, 4 months from the time you file your appeal to the time period in which they will issue an initial decision. That's pretty amazing compared to, let's say the Article 3 courts where you go before a judge, in a different branch of the government. To get a decision within 120 days is pretty amazing. And these judges are going to work with you. They're going to make sure you get a fair opportunity to present your case. And, I can't say enough about how hard, how brilliant these administrative judges are.
Yeah, and that's why I will put out there, one of the things that I hear people say all the time is how fast the MSPB is comparatively to other places. A clarification question that I'm hearing from the chat, people are wondering when the clock for those 30-day window, if they have to file, does it start when they're put on leave, admin leave, or when the termination begins? Does it start the day they get the date on the notice?
Usually it's from the date of the notice in which you, had some kind of adverse employment action taken against you. And as I said, the agency really needs to tell you that, put you on notice that they're telling you that, and then let you know what your appeal rights are. There could be some other instances in which you believe that some employment action took place in which you weren't notified of officially by the agency, but you believe that involuntarily you're being pushed aside. And then it would be basically 30 days from that point where you believe that an agency was taking an action against you inappropriately and bringing that before the board. But again, the judge is going to ask you in that acknowledgement order for more information related to that, just to ensure that the board has jurisdiction over your claim.
Another question in terms of the information that I've heard a lot of folks ask is, some folks have been put on admin leave and didn't download their EOPFs before they lost access. Will they need that to file, or do they just need the action notice?
Well, it's useful to have as much information as you have.
Yeah.
To the extent that you do have that notice, I think if you are bringing the case or you are engaged with legal representation, you would want to have that information to share with counsel so they can review it closely. But again, this is just a reminder to folks who are still federal employees and have access to your EOPF. Make sure you have a copy of everything.
That's the one thing top tip for folks right now, and it can take some time to download. So especially if you've been in government for a while, somebody told me the other day it took hours for their EOPF to download. So I throw that out there. One of the other questions that's coming in, so all these folks are thinking about, whether they appeal or not, their case is going before the MSPB. If there are enough of the same type of case, does MSPB consolidate, or will people sit in a queue?
Okay, that's an interesting question because, again, this is somewhat unprecedented insofar that these mass actions are happening under this administration. And of course, prior to that, we would have individual type actions in which, there really wasn't a need to do what, is being done today, whether it's class action lawsuits. But as you also suggest, under the board's procedures, an administrative judge could be looking at similar claims from parties under, say, one agency, And they can, what's known as to consolidate them, as you said. So that could be done on a motion, either by yourself or your attorney asking for a motion to consolidate, or an agency could make that request, or the judge could do that, sua sponte, or if you will, on their own initiative, just because that's would create a more efficient way of adjudicating the case. So I could certainly see that happening in some of these cases as well. Whether or not it's a class action, I will say in this regard, I understand there are about 4 law firms, and there could be more that are currently investigating or taking on clients who are people who have already been removed under their probationary period under this administration. And those filings before the administrative judge, they will have to look at whether or not to certify that class. So that kind of puts a little bit of a temporary hold on the 30-day notice in those situations. So as it's called being tolling that 30-day period. So if the judge were to come back and say, we're not going to certify this class, then those employees who were contemplated or were part of that initial filing would then have another 30 days to bring an individual action.
So class actions can go in front of the MSPB?
Yes.
Okay. That's certainly something I know a lot of folks are talking about, and there are some websites out there that talk about the class action suits, so people can find out more about that. I will say the other question I've heard a lot on class actions is you have to sign up to be part of the class action initially. Depending on what happens, you may or may not be covered by that class action.
Right. And another thing to kind of remember as well, and again, I'm not giving legal advice as was discussed earlier, but to be mindful as well is that if the fact patterns and how you were treated are basically the same type of legal arguments will likely be made. What becomes more challenging are in situations in which you feel you've been targeted. Now, that could be targeted based on your race, your age, your something that's covered under your Title VII civil rights protections. And so anything that's kind of a little unique to you that wouldn't necessarily be ripe for a class action, and that's something you would want to consider filing on your own. In those instances, those would be affirmative defenses. The burden of proof would be on you to show that that agency took that probationary action based on my age or something like that. I will kind of highlight that, we could put the probationary cases that are also under district court litigation, Article 3 courts that you may have heard about either in California or in Maryland, in which they put together preliminary injunctions to order probationary employees back to service. What I kind of see happening next would be the movement towards reductions in force. And again, that's similarly, we'll have to, I would advise you to keep a very close eye on how agencies are moving out on those reductions in force. Insofar, are they targeting the position or if they're targeting you specifically? And that's what they're not supposed to be doing. Under reduction in force, they're looking at positions that are no longer needed. They're not looking at individuals. And in those situations, the facts and the circumstances could be highly detailed, which would not necessarily lend itself to a class action.
And I guess that's one of the clarification questions then that I'm hearing from folks is if they are potentially represented by a class, if they think they could fit under a class action, can they also file pro se, self-file?
Usually no.
Okay. So you pick one or the other.
Correct.
Got it.
Yeah.
That's helpful. And then for somebody wanted to clarify on the tolling piece, I think you called it. So if you, for the 30 days to be paused, do they have to have already filed to be part of the class action? If you're not in the class action, your 30 days is not paused.
Correct. Now, what's going to be, I will say that's a little unique here, is that action in which people were put back into service.
Right.
It seems to me at that point, the clock would restart.
Because they're back in service.
Because they're back in service.
That's right.
Now, what's kind of interesting, just to kind of break it down a little bit, before the board can typically give orders to reinstate an employee. And by that, an agency has to at least put them back on the rolls, make sure they're getting paid and having their benefits. What's a little bit unique in the California case of the preliminary injunction, what's driving that was the diminishing or lack of services that these federal employees were providing to the public. And the judge was very clear is that I want these people to go back to provide the services. And what we're hearing are agencies are, yes, putting them back on the rolls, but are they putting them back in a work status in which they are providing services? I think the judge appears to be getting frustrated with the government's approach on this, and I would kind of keep watching that space very closely as well.
That's right. There's a lot of moving pieces in real time, which is making it hard for folks who don't follow this as closely to be there. Now, one of the things we talked about earlier, and I want to make sure people understand this, is that admin judges. So you've got your judges that you go in front of your administrative judge.
Right.
What happens if somebody wants to appeal that? Because I know quorum is a big issue at MSPB, and I'm sure people are wondering if they don't get, or can the, well, I guess, one, can the government appeal an administrative judge's decision, and two, can a person appeal it?
Great question, Jenny, and let's break that down. So after an administrative judge issues a decision, the judge also puts, both parties on notice, you can appeal this decision. So either the government or the employee can appeal up to the 3-member board. Now, as you know, there are 2 members currently, and that's all you need. You need to have 2 members to make a quorum. So you do have that option, and there are also time limits on when you could seek what we call a PFR, or a petition for review, which will go to the full board. After the full board issues a decision, we also would issue then your notice information of how to further appeal that. So you have an option. Now, I will say the employee will have an option to file that appeal to the Federal Circuit Court of Appeals. Not necessarily the agency, the agency will actually have to get permission to go to OPM and ask OPM to intervene on its behalf. I will say it's seldom done and seldom approved historically by OPM when an agency loses before the full board. But these are also new times. And so that has, is still TBD on what this new OPM will do. But even if we were to stay now, the other scenario happens at the ID level, the initial decision when an AJ issues it. An employee could bypass going to the full board and go directly to the Federal Circuit Court of Appeals. So there are 2 avenues of appeals for the employee, either go to the full board and then after that go to the Federal Circuit, or go immediately to the Federal Circuit. You do have that option, not the agency. The agency will need to seek permission from OPM.
Which, if there's not a quorum, then you have the one forum to go to the district.
And we did see that during that 5-year lack of quorum. Yes, some appeals remained kind of in a lockdown status until the board was reconstituted. But those appellants or employees also had the option to go to the Federal Circuit Court of Appeals.
Which is a longer process and
Yes.
most likely not a self-filing process.
And that is done on appeal, so that's not kind of where you would go before a judge and produce evidence. Everything that the Federal Circuit Court of Appeals would be looking at is just the written record. What was already in the record for them to review whether or not the administrative judge got the decision correctly. They can look at the entire record, if you will, but they will not be taking new testimony. Even though new evidence could be submitted potentially, it won't be like a full-blown hearing before the Court of Appeals.
Speaking of appeals and going through there, what happens, say I'm a federal employee, I file my case, the administrative judge finds in my favor.
Right.
What can I expect? I know people have been asking, would I then be returned to my job? Would I get back pay? What about attorney's fees? What happens if it's found in the employee's favor?
Okay, so a judge would issue interim relief at that point, meaning that the agency is now required to put you back to the job that you were in with all the back pay and benefits you're entitled to. What could happen if the agency decides to seek PFR, you are still entitled to interim relief, But because the case is still now proceeding, the decision about attorney's fees haven't been fully resolved yet. So it depends on what the full board does. Typically, we would uphold most of the judge's decisions. We could modify them if we want to clarify some of the legal analysis related to the decision. But overall, if the full board affirms the ID, the initial decision, then that stops the agency that, yep, this employee is entitled to all the back pay and being put back into the prior position. And then at that point, if you're represented by an attorney, the attorney will then go back to the administrative judge and provide all the documents related to the fees, and the judge will make a decision on how much the attorney is entitled to.
And again, with so much of this, it's individual, it's case specific, person specific as well. So unless it was a class action, and then it would apply to all those folks. One of the things we're still getting questions on, so I'm gonna take us back a few minutes to something we touched on to clarify, is, we talked about probationary period folks, but now folks are getting RIF notices. But they haven't actually been RIF'd yet. I think they're getting a notice that the agency is intending to RIF. That is not the notice we're talking about for appealing.
It's a great question. You're being given, noticed, typically within 60 days, your position will be subject to removal. At that point, you will be given official RIF notice. I mean, an agency can always pull it back, during this notice period. But that's when you would start to think when the clock starts to tick on filing your case.
So not until something, and just to clarify for folks, until something specifically happens to you that's a action, not just a notice that an action is gonna be taken.
For the most part,
For the
yes.
most part.
There could be situations, outside of this scenario where, let's say you are a whistleblower and you are saying that the agency is taking a series of personnel actions against me based on my whistleblowing activity. This notice could be evidence of a personnel action, but it wouldn't create an independent source of jurisdiction for the board to hear outside of that.
Okay, that makes sense. And then one other clarification question, because people are still asking about how do they know if they're eligible to be part of a class action? Like, how would they find information? I think, as I mentioned, I think groups like Civil Service Strong, and there's some other groups out there that have listed some of those class action suits out there, but I think it depends on just going and speaking to the folks who are running those.
Correct. That's going to be your best source of information. These resources that Jenny just referred to, and the different law firms that are publicly asking people that if you are part of this potential class, contact us and we will let you know whether or not you're going to be part of this class or not. So that is something that will be handled differently versus going to the board and determining whether or not you're part of that class.
That's right. When in doubt, my thing is, we said in the disclaimer, talk to a federal employment attorney.
Yes.
That's been really my thing. Now, one of the other things I wanted to talk a little bit about is you mentioned also, but I want to go back to it just so folks know, because federal employees are all over the country, so are administrative judges, that some of these, I think you mentioned, can be online if they're going to MSPB. Are they primarily online? Are they in person? How does that work?
I think, maybe since our post-COVID environment in which a lot of the hearings, and just to be clear too, even during when there was a lack of quorum at the board leadership level, administrative judges were still hearing cases. And of course, that quickly went to a Zoom environment. But coming out of the pandemic, absolutely, the appellants or the employees, they're kind of the driving force. If they would like to have an in-person hearing at one of the regional offices that we have, you will likely get an in-person hearing. Otherwise, you may just want to opt for a Zoom hearing as well. They're very effective. There are transcripts taken. The judges are very good at how to conduct Zoom hearings, so that is certainly your option. But if you really wanted to have an in-person hearing, you could request that, and more times than not, the judge would grant that.
One of the questions that maybe hasn't come up right now, but it's something that as we're talking is in my mind because it's come up before when I've been working on these issues, is there are a lot of employees that we've talked about finding an employment attorney. When you're filing a case, your agency does not represent you. I think sometimes people think, you know, well, we've got Office of General Counsel, we've got other things. Do you want to talk a little bit about who the agency represents versus employees?
Well, certainly the agency attorneys are required ethically to zealously defend their client, and their client is the agency. And yes, even though employees are certainly part of the agency, they are there to represent management. And even human resources, you know, I've always looked at myself as a chief human capital officer as an honest broker, meaning that I would go to the political leadership and do, you know, the best, good, bad, and ugly with recommendations. But I'm not necessarily there representing an individual or a union. I'm representing the organization. And thereby I give my best feedback to the agency leadership. And sometimes they don't want to hear that feedback. And that's a big tell for me right now, whether or not they're serious in their jobs, because, you know, true leaders want to know what their risks are that they're looking at. And when we're dealing with employee issues, there could be a lot of risks. And so I want to be very clear. And so I do think a lot of your career chief human capital officers or HR directors are in fact honest brokers, but they're not necessarily there to represent you at the individual level. They do have to look at it you know, more organizationally broadly.
I have a sort of related but unrelated question, and so I'm gonna catch you off guard with this probably. But one of the other questions that reminds me that I've heard from folks is, you know, if they're gonna look at OSC or even IG or EEOC names and say their EEO office has been removed or their IG has been removed, can they still file those sorts of an IG claim or the EEOC? I think you can go directly to the EEOC's website for information. You don't necessarily have to go through your agency EEO office.
Well, that's certainly get information, but you know, you are raising a very difficult situation in which there are EEO counselors that are required to kind of do that input and to do that informal counseling. And if they're not there to do that, then they're not meeting their agency's requirements, and they, to me, would be out of compliance with their Title VII requirements. And so they have to be made available. If there are situations in which an agency official is telling you there are no EEO counselors, then you should immediately flag it for your OIG, because that is, I believe, it's a violation of an agency's requirement. And then also be sure to seek some type of representation and let them know that.
That's right, and speak to an attorney about that. So those are the others. Couple other questions we're getting from folks going back, and so we're in the Q&A portion here fully. One of them is, at what phase are cases typically settled? Are they? That's an interesting question.
You know, it's you know, of course, you know, serving in the different jobs that I've had over the year, either as an attorney or as a senior HR official, I can tell you, settlements can happen even prior to litigation. You know, going through an agency ombuds environment or seeking alternative dispute resolution, ADR. You know, clearly when things manifest itself to a filing, that to me, that's something went wrong. You know, there's the communication pathways broken down, and now it's manifesting itself into litigation. So most of the employee disputes or concerns should in fact be resolved prior to some kind of official filing. But once it does file, I can tell you, certainly at the board level or the EEOC level, part of that acknowledgement order that you will first get from the board will be information related to settlement. What type of settlement discussions have occurred, And at some point, even prior to the hearing, a judge is going to say, where are we on settlement? And in fact, many of the cases do settle before they have a hearing before the administrative judge. And even at the PFR level, if you were to appeal a matter after an initial decision, you can also seek settlement or mediation with the board before the full board renders a decision. So if you can think of settlement happen anywhere throughout the process, and it should be encouraged.
Thank you for that. Another interesting question we've gotten, if someone takes VERA, VSIP, deferred resignation, I guess that would be the fork in the road thing. Are those, do they give up appeal rights, or that might be a still TBD sort of question?
That's a really good question, again, to seek legal representation on. Sometimes people will want to bring what's known as an involuntary action, like they were felt that the environment was so hostile, was so demeaning, that you had no other choice but to say resign or take an early retirement. That doesn't forbid an opportunity for you to come back and file an abort action saying that you were involuntarily removed. But the burden of proof is especially difficult to win on those cases. But you can do that, but you always want to be mindful of taking that resignation. It does not put you in a stronger position when you want to come back and claim that you were involuntarily fired.
Right, and you have to think about, you know, the burden of proof and all of those issues too. Relatedly about whether, you know, the different tracks that people can go and raise claims to. You mentioned the inspectors general earlier, Office of Inspector General. One question we've got is, if you go to the OIG, does that preclude you from going to OSC or to MSPB?
It's a great question. No, it does not. You want to use that avenue, and OIG, they're there to kind of protect against fraud, waste, and abuse. They're not necessarily there to make you whole, and only an independent agency like the EEOC or the Merit Systems Protection Board can make you whole, if you will, put you back to a situation in which you were, prior to the harm by the agency, put back into the place that you were before. So going to OIG absolutely makes sense, but OIG will not necessarily make you whole. That's why you could still go to OIG, and then you could go to OSC and say, I notified OIG that about the fraud, waste, and abuse. And in fact, you could also say that before the board, that part of the retaliation that I suffered based on this removal is because I went to OIG. So you can make those arguments in different forms.
Similarly, relatedly about filing appeals, another question. There are some folks who are wondering if they pass the 30-day window because they didn't know. What happens if they're past that 30-day window for filing an action, or since they received their whatever the adverse action was?
You can still make that claim that that there was good cause for me not to have filed earlier. And you know what? Life happens. Sometimes there are car accidents, there are family issues, there are medical things that happen to you that prevented you from meeting that 30-day deadline. So when you're doing your initial appeal, if you believe you did pass the 30 days, be clear in your writings that you acknowledge that you may not have made the 30-day, but it was for the following reasons. And the judge is going to likely order an order to show cause to say, well, say more. Why were you not able to meet this deadline? And we've seen judges grant those in situations. Again, that's a really good question to ask your legal representation. There's board case law on giving examples and when the board said yes to an untimely filing versus when we didn't approve it. So there's board case law that could also be reviewed in these cases, but it's again useful if you have a representative to help you with that.
That actually takes us right into my final question here, because I know we're getting close to time. But the question was, are MSPB proceedings public info, subject to FOIA, are they precedential? You know, can one MSPB ruling then inform other future ones?
Right. So, just on that, most judges, when they give their decisions, those aren't presidential per se, those are initial decisions. If it comes up to the full board and we're looking at it and we're looking at, hey, this brings up a new issue that the board hasn't really reconciled with before, or there's been a decision above the reviewing court over the board through the Federal Circuit Court of Appeals saying, you know what, the board kind of messed up the analysis, in which the board would then issue a decision, will likely be presidential, meaning that from this day forward, all AJs are bound by that presidential order that the board has issued. More cases are non-presidential just because the law hasn't really changed a lot. The standards of proof haven't really changed a lot. It's just the fact pattern. It's only when there's going to be a new legal analysis in which judges are now going to have to weigh decisions on which way to go. Those cases would be presidential. So the board does publish both non-presidential and presidential decisions on its webpage. What it doesn't have are all the different initial decisions that are issued by judges. But if you have legal counsel, there are ways to find those on some of these publishing companies that will publish IDs. Typically, though, they're not publicly posted.
And I think that's another good point of, if you have some of these more unique individual questions, going to an attorney is definitely the way to go on this. So, Ray, thank you.
Can I say one more thing? I know we're running out of
time.
time.
Yeah, this is great.
I was thinking about saying this at the beginning, but I want to say this now at the end, especially for the employees who were moved out of their positions based on their probationary period. Clearly, this is very unique. This has not ever happened before. I spent many, many years at OPM and working with OPM, and this is not my OPM. It's been almost like a body snatchers that this outside team came in with little to no HR experience and is now looking to centralize how we hire and fire across the entire federal government. And I'm reminded by one of the main architects of this process that just recently occurred. He just so happens to be the new director of Office of Management and Budget, who has an outsized role on how federal employees are to be treated. And he said this prior to his appointment. He said this on I believe, a YouTube presentation. When they wake up, meaning federal employees, in the morning, we want them not to go to work because they are increasingly viewed as the villains. He goes on to say, we want to put them in trauma. And if I had heard that from any supervisor or any management official, either representing an agency or as a judge, that is compelling evidence of creating a hostile work environment, in my humble opinion, for employees. So it'll be telling to see what people are going to do with this information, with this evidence. The district court in California authorized a deposition of another OPM official to give this Wednesday a deposition related to those probationary actions that OPM mandated to different agencies across the government to release their probationary employees. So I would just kind of keep an eye on that space, on this upcoming deposition of this individual, and anything coming out of OMB, I would watch it very, very closely.
And I think that's a great point, is there's a lot still moving and a lot still going on. So one of the other pieces of advice we give is the best thing you can do is stay informed right now, because there is so much moving so quickly.
Right.
So thank you for that.
Thank you.
Yeah, Haley, did you still want, I know we have like a minute, did you still want to do a quick poll? Real quick, for those of you that can stay on for 30 seconds. Haley, my colleague, is gonna initiate a short poll that just helps us think about topics for the future, questions that you didn't get answered, things you still would like to know. And you can take it or not, it's your option, but it should be up on your screen. And really just thank you for all this information, Ray. This was incredibly helpful. Thank you to all of you online. We really appreciate you being here and spending time with us, and just, we know you're busy. Keep the questions coming, and please visit our website, Supporting Federal Employees site at ourpublicservice.org. That's OURpublicservice.org. And let us know if there are other resources that would be helpful. And for all there, thank you and really have a good day.
Thank you for your service.